Hello everyone, welcome to LawPutra YouTube channel. Today the case we are going to discuss is Bangalore Water Supply and Sewerage Board versus A. Rajappa. अब इस केस के फैक्ट्स के बारे में बात करते हैं. What happened in this case that जो respondent employee थे उन पर fine impose किया गया by the appellant board for misconduct and various sums were recovered from the respondent. फिर respondent ने claim किया कि जो पनिशमेंट उन्हें मिली है वो प्रिंसिपल ऑफ नेचुरल जस्टिस का वायलेशन कर रही है. देन अपीलेंट बोर्ड ने एक प्रिलिमिनरी ऑब्जेक्शन लिया बिफोर द लेबर कोर्ट और ये कहा बोर्ड इज नॉट एन इंडस्ट्री विद इन द मीनिंग ऑफ द एक्सप्रेशन अंडर सेक्शन 2J ऑफ द इंडस्ट्रियल डिस्प्यूट एक्ट एंड कंसिक्वेंटली द एम्प्लॉयज वर नॉट वर्कमेन and the labor court had no jurisdiction to decide the claim of the workmen. Appellant board का ये objection overrule कर दिया गया तो उन्होंने दो writ petition फाइल करी before the Karnataka High Court at Bangalore. The division bench of the High Court dismissed the petitions and held that the appellant board is an industry within the meaning of the expression under section 2J of Industrial Disputes Act 1947. फिर अपील बाय स्पेशली फाइल हुई जिससे ये केस लार्जर बेंच को रेफर कर दिया गया. अब लार्जर बेंच के सामने ये इश्यूज थे that whether Bangalore Water Supply and Sewerage Board will fall under the definition of industry and what is an industry under section 2J of Industrial Dispute Act. Do clubs and other organizations whose general emphasis is not profit making but fellowship and self-service will fit into the definitional circle. जो यूनिवर्सिटी, कॉलेज, स्कूल, रिसर्च इंस्टीट्यूट क्या वो एक इंडस्ट्री हैं? Could a lawyer's chamber or chartered accountant's office or doctor's clinic or other liberal professions occupation or calling be designated as industry? Are governmental functions strict sense industrial, and if not, what is the extent of the immunity of instrumentalities of the government? क्या सॉवरेन और रीगल फंक्शन चैरिटेबल इंस्टीट्यूशन, म्यूनिसिपल कॉरपोरेशन, हॉस्पिटल, इंडस्ट्री के एम्बिट में आते हैं? एंड फॉर द लास्ट, व्हाट इज द मीनिंग ऑफ द टर्म इंडस्ट्री? कोर्ट ने इस केस में ये कहा दैट बैंगलोर वाटर सप्लाई एंड सेवरेज बोर्ड इंडस्ट्री की डेफिनेशन में आता है एंड बाय जस्टिफाइंग दिस बेंच ने एक elaborating definition दी ऑफ इंडस्ट्री. इंडस्ट्री एज डिफाइंड इन सेक्शन 2J हैज अ वाइड इम्पोर्ट where systematic activity organized by cooperation between employer and employee for the production or distribution of goods and services calculated to satisfy human wants or wishes, not spiritual or religious, but inclusive of material things or service making on a large scale, prasad or food. Prima facie, there is an industry in that enterprise. This later order of the bench headed by the Justice N. Santosh Hegde holds that the bench order needs a review in the view of executive's failure to notify and enforce the amended restrictive definition of industry. After the Bangalore water supply case, Supreme Court एक working principle लेकर आई जिसे triple test कहा गया. What is triple test? For the production or distribution of goods and services calculated to satisfy human wants and wishes, these were the following points were also emphasized in this case. First, industry does not include spiritual or religious services. Second, absence of profit motive or gainful objective is irrelevant, be the venture in the public, joint, private or other sector. Third, the true focus is functional and the decisive test is the nature of the activity with special emphasis on the employer and employee relationship. जो भी ऑर्गेनाइजेशन या प्रोफेशंस, क्लब्स, एजुकेशनल इंस्टीट्यूशन, कोऑपरेटिव, रिसर्च इंस्टीट्यूट, चैरिटेबल प्रोजेक्ट्स एंड अदर किंडर्ड एडवेंचर्स अगर वो ट्रिपल टेस्ट की इस कंडीशन को फुलफिल करते हैं then they cannot be exempted from the scope of section 2J of the Industrial Dispute Act and they will be considered as industry.